Well, this is it. It's the lawyer's turn to talk, so everything becomes a question because nobody really knows. So let's put this in a little bit of context. I think I'm the only lawyer in the room, if I'm right, which is great, which means I've got a captive audience. So I'm going to talk about a couple of things, smart contracts and DAOs, principally because a lot of what we're talking about in these couple of days is around smart contracts, the implementation of them at least. And there's been a lot of discussion around DAOs, their structure. And interestingly, on DAOs, there's been a lot of legal cases, recent legal cases that are beginning to determine what those DAOs are, what they look like, what they can do, how they operate, and so on. This is pretty important structurally to all the projects that we're running. So I'll press down. Next. There we go. So just to put a little bit of context around what I'm going to talk about, the legal landscape. The legal landscape is always evolving. It's forever changing. New cases come along. New projects are tested in court. Statutes and laws are passed by governments. And it results in, broadly speaking, one of three things. Either there's a dead end. We suddenly learn what it is we cannot do. A great case in point here is around tokens. Until last year in UK law, in any event, it wasn't clear that tokens were a thing. Now, what do I mean by a thing? Well, property, something that is capable of being owned. Before the case of Osborne and OpenSea last year, which is all around NFTs being stolen from somebody's wallet that were purchased on OpenSea, it wasn't certain. Now, you might think, of course it's a thing, of course I can own it, I can put it in my wallet and it's there. But unless the law recognizes that, you're in trouble. Because if it's stolen, what does it mean? Well, it's not a thing. You can't own it, you can't recover it. If you can't recover it, you can't get it back. But because of the nominal value that tends to be associated with these things, the courts sensibly have concluded that they are property. Bumps in the legal road. I mentioned tokens just now, but tokens in and of themselves are quite a complex entity. A simple token that allows you access to an event, acts like a ticket. It has some nominal value, but it's just utility. If you then associate tokens with some sort of financial security, the key's in the word, it's a security, suddenly it's a regulated thing. And you have to think, well, hold on, do I need to go and be regulated by the Financial Conduct Authority or wherever you may be, Hong Kong, Singapore, Switzerland? Implementation and interpretation. There's been a great deal of talk about translating contracts into smart contracts, or more accurately, smart legal contracts. Well, how do you do that? We can sit here, the lawyers across the table, we can argue about some point, some clause in a contract, try and interpret what that means and agree a position. Lawyers heavy-handedly tend to use the word reasonable. Well, reasonable is just an objective standard. How do you define something in code that's 0 or 1 on something that may or may not be 0 or 1? Which begs a question, if we take a contract, we translate that into code, maybe the poor programmer gets it wrong because his instructions weren't clear, who's liable? If the programmer gets it wrong, I don't think a programmer is going to be wanting to pick up a multi-million-pound construction claim if they're late or there's some sort of final account dispute. So we've got to think very carefully. And this is where the lawyers begin to branch out into some curious spaces. Are lawyers really going to be reviewing smart contract implementations? Arguably, they should. And we should be defining the test cases. If you have this given set of inputs, then you should have a given set of outputs. And that position should be negotiated and agreed between the parties. I'm talking about standards, of course, standards of interpretation. And in improving map, you probably all know the saying, if it looks like a duck, walks like a duck, quacks like a duck, it's probably a duck. Well, this is how lawyers have to operate, particularly for new and innovative technologies. It kind of looks like this situation, so it's probably this area of law that applies, these rules that apply, and so we can, by analogy, assume that this will be the case. But until it's tested in court, until the government says, no, no, that is the law, we don't know. And so we have to use our best educated guess, albeit for all of these projects. And we touched on yesterday some DAOs, smart contracts as well. I'll talk about smart contracts in a moment, but DAOs in particular are suffering some legal testing in court, which is helpful because it defines where we are. It's also unhelpful because it then increases potential uncertainty if we've got it wrong. So smart contracts, and I'll only touch on this very briefly. I think that DAOs are probably more topical for this session. Broadly speaking, smart contracts, smart legal contracts, and the various hybrid forms they take. By hybrid form, I mean that it might be part code and it might be part natural language. And there'll be some implementation between each of that. And smart contracts, by smart contracts specifically, I mean an implementation of a contract. I do not mean a contract in and of itself. But all of these are valid forms of, let's say, a legal arrangement between parties. And that's recognized in, well, one may say all the major jurisdictions, the US, the UK, Europe, Switzerland, Hong Kong, Singapore, the list goes on. And certainly in common law jurisdictions, the position is, well, if you meet the contract law standards for the test for formation, there's got to be an offer, acceptance, there's got to be some consideration and intent, then you have a valid contract. That's helpful. Even in civil law jurisdictions, and I use Switzerland as an example, within their code of obligations, smart contracts, more accurately, smart legal contracts, are valid forms of contract. Again, this is important because what it means for our implementation in a blockchain environment. But there are challenges, particularly around, I would say, construction contracts, which are notoriously complicated. The last construction contract I executed was about 700 pages long, with all the appendices attached. Now imagine trying to pick up that 700-page document and translate it meaningfully into code to arbitrate the relationship between the employer and the contractor. Good luck with that. I think that's possibly a fool's errand at this point. And as I mentioned, even if we could implement all of it into code, would it be the poor programmer that picks up the bill if something goes wrong? I can't think of any programmer who would willingly accept that liability. And then disputes and disasters. One of the big challenges I always think of in blockchain is that a smart contract is unidirectional. Once the transfer of whatever it is has happened, if something goes wrong, how do you get it back? And this is typified in case law as well. Even I mentioned earlier the case of Osborne and OpenSea. So this was a poor lady who had her NFTs stolen from her wallet. And she had to sue OpenSea, the platform that, if you like, arbitrated that transfer. Now, there was an injunction placed on OpenSea, so they had to freeze the transfer of those NFTs. But that doesn't mean that poor Lavinia could recover them. They're still out there in somebody's wallet. And of course, the hacker's never going to go to that wallet, make themselves potentially known and transfer them back, or they're unlikely to do so anyway. So onto DAOs, and I think more topical. DAOs are an interesting concept, at least legally, at least in my opinion. They are not utopias, and they are not greenfields. And whilst we may all think of DAOs as some form of collaborative enterprise, broadly speaking, they're not. And we have to be very careful about how we implement them. For any given platform, whomever you want to use, Microsoft platforms, Apple, Google, they all have terms of service. Maybe you're a little more adventurous and you use Decentraland or something like this. They're all governed by an end-user license agreement. Now, this is a contract. Your relationship with that platform is contractual based. It is not a democracy. It is not freedom of speech or whatever other rights you think you may have. It is purely contractual. And this leads to a number of concerns, particularly from a legal perspective, adverse terms. There was quite a fun experiment carried out by, I suspect researchers were just having a little bit of a laugh, but they were testing people's appetite to read end user license agreements. And so, being the wags that they were, they put some interesting terms in there. I see some smiles, I think you probably know the story. One of the terms they put in there was that if you come and use our platform and sign up, we have the right and the claim on your firstborn child. So by signing up, you would hand over your firstborn child. On no view would any court ever enforce that term, but it's in there, and there are a number of fun things, particularly, I don't know, go and read the Apple or Facebook or Microsoft, any of those terms of use on their platform, and you will find a number of things in there that are particularly troubling. On the one hand, you're never going to negotiate them, and they will not negotiate them with you. You want to use their platform, sign up and do. But you should be aware of what it is you're getting into. And so because it's contractual based as well, it's the collective judgment of potentially the platform that determines whether or not you can use it. There was another case, and I think it was Decentraland, but I'm not entirely sure, where a user was effectively ejected from the platform, principally because people didn't like that person and their particular views on a subject. There was no free expression in that case. And on a platform like Decentraland, where you own pieces of land, what happens if you're ejected from the platform? Now, if you've spent actual money to buy land, can you claim it back? You can't use the platform anymore. What's your claim on the land or the assets within that space? So a history of not plain sailing. And I mention a couple of cases just because they're interesting, and I'm sure there are others. But some of you may recall the DAO, as it was called. It was around about 2016, if I remember correctly. And so a number of cyber security flaws were, for reasons unknown, published. Hackers exploited those and stole around $50 million in ETH from the platform. And there was no way of getting that back. If I recall correctly, the Ethereum was then hard forked to resolve that problem. And that's a serious amount of money that's just been lost and is irrecoverable, or potentially irrecoverable. More recently, UkiDAO, and I think I was talking about this yesterday with one or two of you. So UkiDAO is, or was, a US-based platform. They got in trouble with the CFTC, Commodity Futures Trading Commission in America, and court found that actually they were running a derivatives selling platform and were selling that to retail customers, which is prohibited. So almost by accident, the platform was running an illegal trading platform. They didn't mean to, I'm sure, but that's what was found. The judge ordered that the members should be collectively, as in jointly and severally liable for $650,000, give or take. And whether or not you would catch any of these members, I imagine you're the one that they do catch. There's a $650,000 bill on your doorstep. And it was shut down, and the judge ordered that the entire enterprise be expunged from the internet completely. So, not a good outcome for the UkiDAO users. So there's pros and cons, all of that to say. But I think for DAOs, there is an interesting legal concept there, and there is legitimacy to it. There are a number of jurisdictions that are promoting them, or certainly making certainly certifying the legal requirements you would need to meet to create a DAO. Probably heard of Wyoming in America, which I think is where Decentraland is registered, if I remember correctly. In Europe, Switzerland seems to be leading the way, certainly in non-profit DAOs. There are a number of other, one may say, less credible jurisdictions, which is something to be mindful of when creating your DAO. I shan't name them because I don't think it's fair, but in any of these projects, there has to be an air of credibility, air of legal credibility and regulatory oversight. And so Switzerland, the UK, the US, all have those structures in place, Hong Kong, Singapore as well. So pros and cons. I think you need to be careful around on the legal wrappers, and lawyers will talk about legal wrappers that go around the DAO. Principally, the idea behind a DAO is collective interest. Everybody gets a vote, everybody gets a say in where it goes and what it does. If you then start wrapping that in different structures, for example, some sort of company, immediately that removes it. Whilst those members may become a shareholder That doesn't mean you have control in the operation of the business. Maybe there's some voting tool. But again, in a company, it's the board that decides what happens. And they don't have to listen to you. You can vote all you like, but they don't have to listen to you. So those types of legal wrappers, I don't think promote and certainly don't support conceptually what a DAO is or what it's designed to be. I think the Swiss system seems to manage that quite well by recognizing them as loosely membership corporations. So there is an air of legal legitimacy to these. How you structure it is what's important, the relationships you have, and being mindful of what those tokens represent. Is it like a share in a business? In which case, is it a security? Or is it a vote? Do you get a say in what happens and where it goes? And just on pros and cons, I think it's all very interesting. I think the biggest challenge that any DAO will face is education of the members. Are all the members on the same page when it comes to voting about certain things? Are they making an informed, educated decision about what it is the DAO is going to do and where it's going? Why are we, broadly speaking, in the West, we're led by corporations? Well, because it's easy to have a small group of people with a like mind doing something together. They will do things faster, quicker, better, cheaper. But there's a disenfranchisement there for the members and the worker bees within those organizations. So all food for thought. And I know there's so many legal topics that have come up yesterday. I know there was GDPR is a big thing, and it remains a big thing, although I tend to think, police cars aside, I tend to think that these are manageable. Intellectual property was mentioned as well. Again, I think those things are manageable. I think the strategies you can employ to do that, which is why I focused on smart contracts and DAOs for this talk. And if you've got any questions on any legal issues, happy to shoot the breeze with you and speculate as to what may or may not be the case and talk about whatever you like. A lot of this is, I'm just going to plug it because I'm here and I've got a captive audience. So with Abel and Mohammed Kassem, Professor Kassem, I've contributed to a book on some of the legal issues around blockchain and smart contracts. Be out next year, I think, early next year, and which incorporates a lot of the themes I've been speaking about here and more. And it's all food for thought when you're building your projects. And good luck to you all as you do build them.